Hi, this is Judge Herb Dodell, and we're going to talk about some practicality here today. If you've been sued and for whatever reason you defaulted, either you didn't answer on time or you didn't do what you were supposed to do and there's a default against you, and now some plaintiff's got a very substantial monetary judgment. It could be thousands or even hundreds of thousands of dollars. Let's say you got served and you had 30 days to answer and you didn't do it. It's possible your lawyer lost the papers. And now all of a sudden you get a judgment in the mail that somebody's got all this amount that's owed to them, and they want to take your examination under oath to find out what your assets are. So what do you do? Is it over, or is there some relief that's available to you for a default? Well, in California, and I've said before, I only talk about California or New York law because that's where I have licenses to practice, or the federal courts. So there are usually, in almost every jurisdiction, and it will vary from court to court, a procedure to set aside a default. And that's what it's called, setting aside a default. It's a motion to vacate. In other words, set aside what it was previously decided against you. Now, the grounds to setting it aside are inexcusable neglect, failure, negligence, and things of that nature. You just didn't know. You made a mistake. And generally, in California, for sure, you have to make that motion to vacate within 6 months of the time of your notice. If you wait too long, it'll be over. But if you go to court, if you can get lucky enough to get your lawyer to admit that they made a mistake, you know, the dog ate the homework, it's located in the bottom drawer, whatever it is, in California it's mandatory that the court set aside the default against you because of the excusable neglect of, or even inexcusable neglect of the lawyer that you hired to represent you in defending this case. You have to make a motion, a formal motion to the court, identifying all the things that went wrong, or the things that you were out of the country, you weren't anywhere near when the complaint was served, anything like that. It rests in the sound discretion of the trial judge. And when I talk about discretionary calls, most of the time, discretionary calls are not disturbed on appeal. Not disturbed on appeal, unless you're able to show that the decision made by the judge was arbitrary, capricious, it really wasn't based on any reality or state of the law that would be appropriate to these particular facts. And so this is your best shot. You must make that motion on a timely basis. If you can get your lawyer to admit it, it's called a declaration of fault. That will get you relief from the default. Otherwise, you take your chances with some judge deciding whether they want to give you a break or not.